Hello, welcome back everyone. In this video, we are going to start a new chapter, the Indian Contract Act. Before going into the chapter, let me give a small introduction about this. In India, we have so many laws to provide security to the lives and properties of the people, to maintain peace, harmony and justice, and to regulate the lives of people. We have many laws like constitutional law, civil law, criminal law, labor laws and so on, and one such important law is the commercial law. The commercial law, it deals with all the commercial activities taking place in our country, like all business and trading activities, contracts, copyrights, trademarks, mortgages and so on. And one important act under the commercial law is the Indian Contract Act. This act was passed long before we got independence. It was passed in the year 1872. Now, what is the meaning of contract? Most of us will be knowing the meaning of contract. It's an agreement entered into between two or more persons is called as a contract. In our country, whenever we begin any economic activity or even some social activities, we start with a contract. And the basic belief is that when we enter into a contract, it is safe and secured. The concerned parties will keep up their promise. They will act according to the terms and conditions given in the contract, and they will not cheat. So this is a basic belief when we enter into a contract. We feel that it is safe to start any activity with a contract. This safety or security is provided by the Indian Contract Act. This gives legal protection to all the contracts entered into in our country. So most of the activities, whether it is a business or trading activity, or whether buying and selling of properties, or renting or leasing of properties, or entering into some, taking some person for employment, or mortgage, pledge, taking loans, for all this, we definitely enter into a contract. And we believe that once we enter into a contract, the concerned parties will act according to that. So it's safe to begin any economic activity with a contract. So this assurance that this safety is provided to contracts by the Indian Contract Act. So indirectly it helps all the business activities. Every day number of contracts are entered into in our country, and the main objective of Indian Contract Act is to see that the concerned parties act according to the provisions given in the contract, and in case of failure to do so, if they fail to do so, appropriate actions will be taken against those persons, and at the same time appropriate relief, compensation or remedy will be given to the affected party. Now let's see what's given in the book. The Indian Contract Act occupies the most important place in the commercial law. The main object of Contract Act is to assure that, the main aim is to see that the rights and obligations which arise out of the contract are carried out, and in case of failure to do so, the remedies are made available to the affected party. So the main aim of Indian Contract Act is to see that the rights and obligations are followed or carried out, and if they fail to do so, appropriate remedies. Remedy means some sort of solution or compensation is given to the affected party. Without Contract Act, it would have been difficult to carry on trade or any other business activity. Whenever we start a trading or business activity, we start with a contract. And we believe that if we enter into contract, it is safe. So this belief is protected by the Contract Act. So because of Contract Act, we can do any activities without any fear, any business activities without any fear. The English Common Law is the base for the development of Indian Contract Act 1872. This was passed before we got independence, and so many of the provisions are taken from the English Common Law. The Act came into force on 1st September 1872 and applies to the whole of India except Jammu and Kashmir. Now, what is the meaning of contract? We all know it's nothing but an agreement between two or more persons, but the Indian Contract Act gives a detailed explanation for contract. Let's see what's that. Now, I've given an example first so that you can easily understand the meaning. Here in this example, A is ready to sell a particular brand of his car for rupees 4 lakhs. He places an offer that he is ready to sell his car for rupees 4 lakhs. Now B comes to know about this offer We can say this either as an offer placed by A or a proposal placed by A. Now B comes to know about this offer and B says that he is ready to buy the car paying 4 lakhs. So B is accepting the offer. So when an offer is accepted by another person, it becomes a promise. A promise arises between A and B. A is ready to sell his car and B accepts to buy the car. So a promise arises between A and B. So when a proposal is accepted by another person, proposal is placed by A and that is accepted by B. So it becomes a promise. Promise is proposal plus acceptance. Now, along with that, there is a consideration. Consideration is, for A, the consideration is 4 lakhs and for B, the consideration is the car. Consideration means something which we get in return is called as consideration. Now, A is giving his car to B and in return he gets rupees 4 lakhs. B is paying rupees 4 lakhs to A and in return he gets the car. So, both of them get some consideration. A gets rupees 4 lakhs and B gets the car. So, when a promise is accompanied by a consideration, it becomes an agreement. So, promise along with consideration. For A, the consideration is 4 lakhs and for B, the consideration is car. So, promise along with consideration forms an agreement. Agreement may be written, oral or implied. Now, the example which I gave you above can be either a written agreement or it can be an oral agreement. Implied agreement means which can be understood by the behavior or by the circumstances or situations is called as an implied agreement. For example, a person enters into the hotel. You're going to a hotel and there will be a menu and you're ordering the food in the menu. It is the duty of the hotel owner to supply the food. And it is your duty to pay the bill of the food properly. So now there is an implied agreement. There is there is no written agreement or no oral agreement. Here an implied agreement arises between the hotel owner and the customer. The customer can order the food and the hotel owner is bound to supply the food. And at the same time, the customer also must pay the bill to the food properly. So these types of agreements are called as implied agreements. Agreement can be either legal agreement or social agreement. Legal agreement means which can be enforced by law, which can be put into force by law is called as legal agreement. The agreement which I gave above, A offering to sell his car, it's a legal agreement. Social agreement means agreement between friends or between relatives, family members. For example, if you call your friend for a dinner and he or she says okay and later on he is not coming. So in this case, you cannot legally enforce it. You cannot go to the court and put a case against your friend for coming to the dinner. So this is called as a social agreement. Social agreement is not enforceable by law, but legal agreements are enforceable by law. Legal agreements are called as contract. Agreement which is enforceable by law is called as a contract. So remember these three terms. Promise. Promise means a proposal should be there and it should be accepted by another party. So an accepted proposal is a promise. Where there is a consideration for a promise, it becomes an agreement. And when the agreement is enforceable by law, it becomes a contract. There are certain important terms which is defined under Indian Contract Act. First one is offer. It's also called as proposal, section 2A. When one person signifies to another, signifies means express to another, his willingness to do. Offer, it can be for two things, for positive as well as for a negative thing. Positive means if he says that he will do something, it is a positive act. And if the person says that he will not do something, he will avoid doing something, it is a negative aspect. So it can be for two things. When one person signifies to another his willingness to do or to abstain from doing anything. Abstain means avoiding doing something. He will not do something. So that can also become called as an offer. For example, here in this example, A says B that he will not sell the car to anybody else until B pays the amount. So here he is abstaining from doing something. That is, he is not going to sell the car to others. So he is abstaining from doing anything. So offer can be for two things, either for doing or for not doing something. So his willingness to do or to abstain. Abstain means avoid doing certain things. From doing anything with the view to obtaining the assent of that other person. Assent means the consent of the other person. The other person must be willing to accept the offer. Either to such act or abstinence, he is said to make a proposal. So why this person is placing an offer with the aim of obtaining the assent of the other person, to know whether the other person is willing for that. In this example, B is ready to buy the car. So B has given his assent. So either to such act or abstinence, he is said to make a proposal. Acceptance. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So one person is placing the offer and the other person, he signifies. Signifies means expresses his assent. He says that he is willing to do according to the offer. He is willing to act according to the offer. So he signifies his consent. He gives his assent to the proposal. In that case, it is said to be accepted. Next one is consideration. Now regarding consideration, remember two things. First thing, it can be for doing something or for not doing something. For doing or abstaining from doing something. Second thing, consideration can be either for a past act or for a present act or for a future act. Consideration will be for something which you have done in the past or for something which you are doing in the present or something which you are going to do in the future. When at the desire of the promiser, the promisee or any other person. Remember, in the example which I gave you, for A, B is the promiser and for B, A is the promiser. So mutually they become promiser and promisee. So when at the desire of the promiser or promisee when at the desire of the promiser, the promisee or any other person has done or abstained from doing something. This is a past act, so it's given in past tense, done or abstained from doing something. And here next comes the present thing, or does or abstains from doing something. So now he is doing or he is abstaining from doing something. It's given in present tense. And look at the future tense, or promises to do or abstain from doing something. He says that in the future he will do something or he will not do something. Such act or abstinence or promise is called a consideration for the promise. So such act, whatever he does, or abstinence, whatever he is not doing, becomes the consideration. In this example, A sells the car and gets 4 lakhs. B pays 4 lakhs and gets the car. So A gives the car and gets 4 lakhs and B gives 4 lakhs and gets the car. So that is called as consideration. Hope you all understood. Thank you.